She has an open case upstairs that's also in warrant status. Frank has been talking with Judge Nelson in the
Is this, may I have the case number, please?
252 1200.
Okay.
Because she has a felony warrant, I'm not going to release her. We'll do PC now, and I'm going to keep her, and then Frank's going to run up to the 482nd to try to get her a bond set there.
It looks like probable cause was found on July 25th, Judge.
I'd like to know, but I don't know. All I know is that she's charged with assault. She also has an injury to a child. It looks like they're out of the same transaction.
Yes, Judge.
You're facing up to a year in jail and or a $4,000 fine on the assault. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you then.
On June 24, 2024, off with multiple complainants, and one of the complainant's mother, Dr. Clinton, this case investigated an assault that occurred in an apartment complex. Complaint stated that on Wednesday, June 5th, 2024, this complainant, part A, the complaint that they met, the brother is the complainant in this offense who's 15, and his friends were walking their dog and found a juvenile male who's the son of the defendant over problems they had in school. Juvenile male's mother, the defendant, exited her apartment unit, started to confront the complainant and followed co-complainant and this complainant to a fence. The other complainant felt the need to defend himself due to the now defendant being close to him, but he did not assault the defendant. Defendant pepper sprayed that defendant and that complainant, this complainant, attempting to get her to stop by swinging at her. Defendant also pepper sprayed this complainant, but only hit one of his arm. The other complainant felt pain from being pepper sprayed by the now defendant, and the first complainant, the mother of the other complainant, wanted to pursue charges. A witness who lived in the apartment complex corroborated the statements of all the complainants.
So who are the complainants now?
So
relation?
It is brother complainants and their mom, who is another.
The prosecution is aggressively laying out their case, and on the surface, it looks like a total slam dunk, an open and shut situation that should be over in minutes. But here's the secret about Judge Fleischer. He isn't just absorbing their narrative. He's dissecting exactly how they intend to prove it. In this high-stakes arena, evidence might be king, but procedural integrity is the entire kingdom. If the state missed a single detail or failed to dot their I's and cross their T's during the initial investigation, Fleischer will sniff it out instantly. The real question is the defense sharp enough to catch the scent and pivot before it's too late?
Complainant, but I don't know if they.
So it's familial.
I think it's the two boys, the complainants, but one of them's 15 and older.
So they wrote it as complainants, but it only accepted charges. So I guess the way they verbalized it initially to the officers, the way they wrote it down was complainant 1, 2, and 3, or
Okay.
2, complainant 2, mother, complainant 1. So formally, in terms of the charges, there is the complainant upstairs for injury to child, and then this complainant is 15, which is why it's right above the felony level. But they wrote the mother as complainant, I guess, to the surface.
Ours is
The complainant here is a 15-year-old.
no familial relation.
None.
No, it's just that their brothers and friends encountered the juvenile male, the son of the now defendant, over problems they had in school. So it seems like there was a schoolmate issue.
Okay. Ma'am, did you want to say something? I'm sorry.
I mean, I know that we'll fight the facts in the future, but she takes care of 3 children. The son that they're talking about, the son's 12 years old. Looks like there was some argument between these kids, and just to make her point of view, she was trying to speak with the complaining witness's mother regarding this whole situation. Looks like it got out of hand. I do have a picture from the defendant regarding an injury that she received from a busted lip of that day from the juvenile. Moving forward, I would like to set a bond, at least at the minimum, of $1,000, and it'd be a PR bond.
Great state of Texas.
Judge, I just need seconds. I was trying to look up something else that wasn't popping up. Your Honor, state requests that reasonable bail be set because this is not the only complainant involved. Obviously, there's the felony as well, and the fact that she has been charged prior for a disorderly conduct with a deadly weapon, assault family member.
The injury to a child, it's what, 14, right? 14 and under?
Yes, and the other complainant was 12. So that's why there's a felony and a misdemeanor, and the fact that they're both involved and there was a witness is that allegation still continues on, and so state requests reasonable bail be set at 7,500.
Family violence was dismissed, Judge. The only conviction I see is theft.
Yeah, I mean, I see
2009.
2 dismissed, I see dismissed it orderly. Do you have any like out of state or anything else?
I'll run the I don't believe it's
Okay, well,
it's not enough for me to impact mine.
right.
Oh no, it's down here. Never mind. Sorry, they're all in. But
So it looks like the only possible conviction that I see is a theft from '09.
yes, Judge.
And the other 2 cases,
The only bond forfeiture is very.
okay. Ma'am, I'm going to find that there's probable cause to go forward with your case. I'm going to set your bond at $1,000 and I will give you a PR bond now, but I'm not going to play this game. I'm going to protect everyone in my community at all costs. I don't care who you are, where you come from, doesn't matter. You understand? As part of your bond conditions, you're not to have any contact with the complaining witness in this case and not to be in possession of any weapons as well. Weapons is a very loose term. So if you have any questions, talk to Frank, because no weapons whatsoever. I'm also ordering you not to go where they live or where they work as well, man.
I do have a concern about that because do they live in the same apartment complex or is it a different?
It was the children that are schoolmates, so I don't think there's otherwise, but not that I could find. I'll take a closer.
They were
look.
just roaming around.
Her head, so I don't believe that'll be an issue.
Okay.
And so you're okay. I'm going to attach you to this as well. I'm going to go ahead and email Judge Nelson.
This is the ADA on record. I'm just helping out since we're shorthanded, and but I'm not opposed.
Okay, I have emailed you guys and I CC'd you guys. I've also talked to her. Would you please take a seat in the jury box? Do not leave until we have you sign bond conditions and then until Frank gets back to talk about the bond. Okay?
Thank you, Judge.
Rodriguez?
No, ma'am. Jury box. Come on up. Yes, sir.
Daryl Bohana, Your Honor.
What's the last name?
Bohana?
Vaughn. Okay. This is the person that got out of ICE custody, right?
No, Your Honor, this is another individual. We came in November for the arraignment setting, and he was a truck driver.
The tension just spiked as the defense fired off a sharp objection. And for a split second, it looked like Judge Fleischer was going to shut them down. But wait, there's a massive twist. He's actually sustaining it. For those of you watching at home who don't speak high-level law, that means the prosecution's line of questioning was completely out of bounds. Usually, these legal skirmishes erupt over hearsay or relevance. But today, it looks like the state was trying to sneak in unverified evidence through the back door. You can't just wait in a room this prestigious. This isn't some amateur garage band rehearsal. It's a court of law where every word carries the weight of a lifetime.
Commercial driver, and you put a restriction because he was actually had an alcoholic beverage allegedly in his possession at the time so that he could not drive. So you informed me that if he abides by his conditions, that you would give him the opportunity to perhaps have some sort of device, either to his vehicle or a portable scram.
Is he here?
Yes, sir.
Come on, Ms. Bahana.
So that he can get back to work. How are your holidays, Judge?
Are you
It was good. Good, yeah.
getting ready for the freeze?
Oh, yeah, we'll see. I mean, I'm supposed to have a jury trial on the 21st, so we'll see if that goes.
I don't know. Bringing all those jurors down here with all that weather.
Yeah, I'm not sure because, accusing gets a little skittish with cold weather. They shut everything down.
Good morning, Ms. Bahana. The only thing that I'm trying to impart to you is that it's a privilege. It's not a right. Driving, it's just a privilege. You want the right, you can walk. Otherwise, it's just a privilege. And it's just elementary that you're not supposed to do certain things in life. What I'm trying to do is trying to get you just to appreciate the awesome privilege it is to drive. You understand? So he drives trucks for a living. How are we going to do it?
Well, Your Honor, I believe, I'm not sure if you would think that a portable was acceptable, but if a portable wasn't acceptable, I would recommend a scram device, Your Honor.
So what I'm going to do is, do you drive 18 wheelers?
Not sure, Mr.
Yes, sir.
Can you put a device on an 18 wheeler?
Not the companies, but I drive for a company.
So you're driving a company vehicle, not yours.
No.
You don't own the vehicle.
No, not the truck, no.
Okay. So what I'll do is he'll have a device on his personal vehicle. Okay. And then we'll put a scram on him and I'll allow him to drive the work vehicle. But the scram will tell me at all times whether he's consuming anything. I'm putting a device on your ankle to measure whether you're consuming any kind of alcohol. Don't. Anything you put in your body, make sure you know what it is. Because if there's any doubt, don't put it in your body. You know, Listerine, mouthwash, whatever it may be. Certain things may have alcohol. Certain fruits ferment, turn into alcohol. So you need to be aware of these things. Know what you put in your body, because if I find any kind of alcohol consumption, I'm going to take it away again. You understand?
Sir.
Okay. All right.
Your Honor, and I'm sorry, Judge.
Go ahead.
Mr. Rohana has been attending a couple AA meetings, just for the knowledge of the court. He's trying to learn how to better handle alcohol problems. He hasn't been working since November. I'm not sure how much he has saved up.
I'm going to pay for it.
Oh, okay.
I
Thank you,
always
Judge.
pay for everything.
Okay.
Don't worry about it. Money should never be an issue. I pay for everything for everyone, so it doesn't matter. So scram, and then, well, he's here now. We might as well get it here because this is where we get it, right? And then the interlock within 7 days, and then waive the fee for both, please. Okay.
And we're still waiting on body cams and station videos on this case, Your Honor.
Doesn't,
pretty
it doesn't matter.
I believe it's uploaded. I'll double check, but there are videos that were just shared with people.
Okay,
Yeah.
he just shared it. Thank you, Judge.
Okay, guys, take care.
This brings us to a massive ethical crossroads. And I want to hear your take on this. When a person's entire livelihood and ability to provide depends on their right to drive, yet serious concerns regarding alcohol abuse are looming over the case. Where do we draw the line? Should the court system prioritize structured, monitored rehabilitation to keep people working, or should they impose a scorched earth, complete restriction regardless of the devastating employment consequences? It's a brutal choice between public safety and a human being's survival, and the stakes couldn't be higher.
Sangha,
Morning, Your Honor.
sir, you are wanted out of, you say Fayette,
Yes, Your Honor, Kentucky.
from Kentucky for theft by deception of up to $10,000. Your lawyer has asked for me to set you a bond, and I'm going to tell you now that we don't set many bond in fugitive cases because you are an inherent flight risk, right? You're wanted from a different state, and we're putting a lot of trust that you're actually going to go back. You're old enough to know that actions have consequences, right? I'm going to set you a bond today because they're not opposed to it. She's asked for a $1,500 bond. The state's asking for a $5,000 bond. I'll set your bond at $2,500. Because it's a fugitive case, typically you'll have to make all of it. They don't usually do the 10% because, you know, you're a flight risk. So the thing that you need to understand also is that I'm only going to do this one time. I'm not going to do this again. I will give you one bond. And what we do is we give you 2 weeks from the date of your release to go turn yourself into Kentucky. If you do, and you get the proof to Ms. Morgan here, they'll dismiss this fugitive case against you. If you fail to go, you got to know that there's a consequence, and the consequence is huge because I will revoke the $2,500 bond.
And there you have it. A total masterclass in judicial temperament delivered by none other than Judge Fleischer. He managed to maintain absolute order, educate every soul in that room, and deliver a crushing high-pressure ruling without even breaking a sweat. Whether you're cheering for the outcome or reeling from the shock of the decision, you have to respect the sheer precision of the process. If you found this legal breakdown as intense as I did and want more deep dives into the hidden strategies of courtroom, smash that like button and subscribe right now. Because in this room, the truth isn't just a concept. It's the only thing on trial.
Zero. And I'm going to issue a nationwide warrant for your arrest, and I'm not going to do this again. I'll get you eventually, and this time I'm going to hold you until Kentucky comes and gets you. Do you understand?
I understand, yes, Your Honor, but the only problem I might have is with the full amount, paying the full.
This is not a negotiation, right? I'm going to tell you that $2,500 is a very low bond for a fugitive case as it is. So I can tell you probably on one hand how many times I've set a bond at that amount or even lower. So the other thing you need to understand, Mr. Asanga, is that for you to post bond, you have to withdraw any waivers that you've made. Did he waive? Ms. Morgan, did he waive? Okay, so it's a non-issue then. I don't need you to make a decision now what you want to do. If you want to waive extradition, we give Kentucky 14 days to come get you. If they don't come get you within that time, Harris County releases you. I'll give you time to talk to Ms. Morgan to tell us what you want to do, whether you want to waive, whether you want to try to make bond. It's up to you.
I would like to make a bond.
Okay, so I guess
The reset then, last date is the 30th. Well, the 30th would be court date, but the morning of, check if we haven't heard back first.
what I would suggest is probably not setting it off 2 weeks, just in case that there's an issue. I mean, if you definitively know someone's going to post a bond, then go for the 2 week, But if you've spoken to family and they're having trouble, then just do it, right, so that we didn't sit
I
there for
might
2
be out of
weeks.
town that week, Your Honor, so I would approach sooner.
I Zoom. That's why I have it, so you can always, we've had people come in bathing suits, So, okay, all right. Good luck to you, sir.
Thank you,
Your
Judge.
Honor.
Is one of them yours?
Ventura.
Let's do it together.
You ready?
Yeah, come on.
Oh,
Bring it.
okay. I didn't know.
It's deficient. Take your time.
Y van a contestar a voz alta, no puedo interpretar.
We're Mr. Gil Rodriguez,
Rodriguez.
and you
Yes.
are Mr. Ventura.
Señor Ventura?
Sit.
Yes.
Both of you
Los
have
dos
picked
de
up
ustedes
criminal
tienen
cases.
delitos criminales.
Both of you have
Los
worked
dos
out agreements
han
with
llegado
the
a un
state of
acuerdo con el
Texas.
estado de Texas.
You need to understand that the agreements that you guys are working out today will reflect as convictions on your record.
Sus convicciones
Once you plead guilty, there's no turning back. It will go on your record,
van a estar,
and it will be there for the rest of your
van a
life.
estar allí para todo.
You give up many valuable rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. And like I told you earlier,
Las leyes federales, como les
once you
dije,
plead,
no, al
it's there
declararse,
forever. It's even there after you die. You can never take it off. Mr. Gil Rodriguez, you are charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine.
$1,000
The agreement you've worked is 7 days in jail. Credit for the 7 days that you've done. Is this how you understand it?
I understand guilty.
All right, I'm going to find you guilty. I will follow the agreement, send you to it. I'm going to tell you now
Voy a
that
decir ahorita,
any more cases you pick up, you will be facing a minimum of 90 days in jail. No more proverbial slaps on the wrist.
no los vamos a dar.
Mr. Ventura Lopez, you were charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine, and you worked out an agreement where they're offering you 6 days in jail with credit for the 2 that you've done. Understand, by pleading guilty to this offense from now on, you will be facing a minimum of 30 days in jail. You understand?
Yes.
Is this what you want to do?
Lo que usted- Yes.
How do you plead to the offense of driving while intoxicated? Guilty or not guilty?
Hablo no culpable. Guilty.
I'm going to find you guilty, sentence you to the agreement.
Al acuerdo.
I'm going to tell you now, anytime you get pulled over, officers will look at your record. They're going to see that you have a prior DWI. If they come up to your car, they smell alcohol on you, it's probably not going to go well.
No le va a ir.
If I were you, for the rest of your life, if you want to get lit, don't get into a car
No se meta un auto.
because it's a humongous gamble. I'm suspending your license for 90 days. Do not drive until you get a license.
Tenga una licencia de conducir.
Yeah. You're appointed on the case?
I am, Judge.
Okay. I'm going to tell you one more thing, that DWI is big business in Texas. There is a $3,000 surcharge that normally we would tack onto this. On a second DWI, it is a $6,000 surcharge that you can look forward to on another one. So be careful. Don't come back.
Y no
All
regreso.
right.
Thank you, Judge.
Yeah. All right. Good luck, guys.
Are you waiting the search warrant? Oh, thank you,
No le van a
Judge.
cobrar los 3,000. ¿Tiene gracias?
Do I know you?
Thank you.
I mean,
Le van a cobrar los $3,000.
gentlemen, that way. Holy moly. Wow. I'm here. Great to see you.
Good to see you, Judge. I'm here on Amanda Hale.
Let me see. It's with an H, right?
Yes, Judge.
I don't see it. Is she in custody?
Yes, it's on the fugitive docket.
Oh, fugitive. Okay.
She is wanted out of Hines County. She has a pending case in the 182nd. She is asking for a bond to be set. She wants to go to Hines County and handle it herself. She stated that she has attempted to do so, but was told that her bonding agent quit 2 years ago. And in the interim period, she got arrested on this.
He has not made bond on the felony case yet.
That is correct, Judge.
Do you know if she's going to?
She said that she was.
Okay. Great state of Texas.
Sorry, I just want to check one quick thing before I reply regarding that. Oh, yeah, it looks,
I don't even know what the charge is.
oh, it's
I guess-
burglary, Your Honor. State would be opposed to bond, the fact that, number one, that she hasn't yet made the bond, but it had been set for 10,000.
But the problem is like a lot of times, you know, it really doesn't tell me much because a lot of times they'll go try to bond out, but they're unable to because a particular bonding company says, oh, well, you got a fugitive case, you can't get out anyway. So the fact that they haven't made bond doesn't really tell me anything because I don't know if they tried and were denied, you know?
Yes, Judge.
So
So she does have some history. She was recently convicted in Galveston for a deadly weapon that was originally charged as aggravated assault with a deadly weapon. And was burglary habitation was dismissed pursuant to that plea.
oof.
She also has had some history in that same. She was charged previously as a fugitive, but in openness, it was a lot older. But she has had a prior fugitive case in '95. She also had a prior larceny two prior larceny charges, and a grand larceny charge. So state would be opposed.
I do, it's going to be high.
I understand, Judge.
I mean, it's going to be like,
Oh, sorry. And this warrant has also been active for a hair over a year, possibly longer, but it's a state of warrant issued out. It's like January.
do you know if she took flight?
For that, I wouldn't be able to say, but it was in.
Can you
well,
find out?
Technically, yes, because she was charged with UUMV for the pendency of the warrant. So I don't know why they didn't place it when she was originally arrested for the UUMV in the 180th, because that's since been dismissed. But my point is, when she was originally arrested, I don't know why they didn't.
Yeah, I don't know, Shalom. I mean, it's just way too much. She got an ag assault over there. And you said that's recent too?
That was last year. It was a conviction, but it was pled down to deadly conduct. So it was originally charged with ag assault and burg hab, but then pled down. It
Like,
was
how long ago?
September 2024 was the conviction, I think. But let me double check. I don't want to misspeak.
So she picks a UUMV here.
The conviction was, oh no, sorry, July 3rd, 2024. My mistake. So July 3rd, not September 3rd. So. Then also a PCS, but that was dismissed. March of June. In Galveston, not here. Well, on top.
UUMV dismissed.
I'm sorry?
It was UUMV when it was on the PC. It's gonna be high. I mean, if I said it's probably like north of 20, you know, and she's gonna have to make all of it, you know. So I guess let her know if she's amiable. Has she waived already?
She's waived already.
She can, if she wants it, she's gonna have to do the waiver withdrawal. She'll lose all that.
Hello, Judge.
Absolutely. Yeah. Do you mind bringing out Miss Hale, please?
Mine is easy, Your Honor. I'm
Tell
just
me.
asking for a reset on the gentleman I'm having court here today.
Is it old?
190 days.
Oh,
It's 190 days. I'm just setting it for a plea.
okay. You got it.
Thanks,
No.
Judge.
That way, when they hear it from your mouth, Judge,
That's okay.
it's like I didn't sell them a wolf ticket.
What about the song, fugitive guy?
We're waiting on them to, I don't know if they're, oh, So do you want me to set the bond at 2,500 for Asanga? Did we confirm?
Oh, no, we hear back from Stacy. She went into holdover.
So he said it at, let me make it. Good morning, ma'am.
Morning.
Shh. You are wanted out of the state of
Mississippi.
For a burglary, Your Honor.
for a burglary charge. Your lawyer is asking me to set you a bond. I don't know. You know, one of the main things are you a danger to my community? Because if you are, it's just not going to happen. I'm going to do everything in my power to protect my community at all costs. You know, I have a lot of people that tell me, you know, little bunnies jumping in the woods, that's who they are. But when I look on paper, they're a completely different person. Mr. Kim, would you mind telling us about Ms. Hale, please?
Yes, Your Honor. She's currently also being held in the 182nd for second-degree level of possession of a controlled substance. She was recently convicted in Galveston County for a deadly conduct charge that was initially pled as an aggravated assault with a deadly weapon, along with a burglary habitation that was dismissed, presumably with a plea deal. She was also previously charged with possession of a controlled substance that was dismissed earlier last year as well. She was previously a fugitive, charged as a fugitive in the 90s, along with a few other charges from Mississippi, 2 charges of larceny, 1 charge of grand larceny, and obviously these offenses.
Yeah, I don't, it's too much baggage, man, you know, and especially you also telling me that this case is over a year old.
Or the warrant, that one was issued out on January 10th, 2024, Judge. So it's been 1 year.
Do we know if she knew about it?
That I wouldn't be able to say. I don't know if it's an FTA, Judge. I can find out, but I don't know the answer to that point. It typically says, it just doesn't say.
Here's the deal. If I were to set you a bond, you would have to make, I think you would have to make all of it. It's not something where you can pay the customary 10% because you're an inherent flight risk and you have a prior fugitive case as well. You know, I don't think, I'm not going to set you a bond, man. You just got way too much baggage. You have a prior failure to appear. This case is a year old. You've got a second-degree felony. Is it with intent to deliver?
No, Your Honor, it's just the amount forwarded to
Yeah, it's just too much, ma'am. I'm sorry. So the deal is this, is that you have 2 choices now. You can waive extradition, which in this case, normally what happens is we give the other jurisdiction 14 days to come get you. And if they don't come get you, Harris County releases the whole. But for that to happen, you have to make bond on the felony case. Because you have not made bond on that case there, it's kind of in a holding pattern until you either take care of that case or you post bond on that case. If you post bond on it, that will get the 14 days to start kicking. Okay?
She's already signed a waiver, Judge.
Oh, she's waived.
Signed it at the Met.
Oh, okay.
Already, Judge.
Got it. Okay. But just to give you information, I don't know how much you know or not, but right now we're basically in a holding pattern anyways, just because you've not made bond on that case. Okay? If you don't understand, I can have Michelle tell you more about it so that you can get a good grasp on what everything is. But understand, it's just too much baggage, man. Okay? All right. Thank you. Thank you. Good morning, ma'am. Ms. Ambrise Villarreal, you were charged with theft by check. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Yes, Judge. On August 27th, 2024, the defendant issued a check to the Harris County Tax Assessor's Office in the amount of $174.25 as payment for 1 vehicle registration and a vehicle registration sticker. The bank returned the check marked insufficient funds, and the complainant has provided a copy of the demand letter to the defendant via first-class mail with the affidavit of service attached. The letter was not responded to.
All right. Ma'am, I'm going to find that there's probable cause to go forward with your case. Do you have a lawyer today? Do you speak English?
Yeah.
Did you want to apply for an appointed lawyer, ma'am? Okay. Let me see if I have one on file. I don't have one on file. I'll give you an application. If you qualify, I'll provide you a lawyer today. I'll have you sign a reset with Victoria and then we'll have you fill it out, ma'am. I don't want you to say nothing. Please, everything you say, they can use against you to prove guilt, and just
Um,
when we give you a lawyer, you can talk to the lawyer. Okay? Please.
Judge, any conditions or no? Yes, Judge.
No condition.
Judge, on Mr. Fox, the state's currently talking to felony to make sure that they're authorized to do that time served. Would you be willing to terminate his probation case, his criminal mischief deferred? Or would you?
You guys think that's appropriate? What do you think on Mr. Fox?
That, he does have an open MAJ, and so we could either time serve him along with the DWI, unless we coordinate with the felony, or really whatever the court, feels.
Doesn't matter to me. I mean, I didn't want to even take anything because I think he needs to go to treatment, but our hands are really tied because of Fort Bend. Can't do anything.
They may even give him treatment once the holds are done here, Judge. I don't know, but it's sort of like we can't give him treatment because of those cases. They can't give him treatment because of these cases. And so.
We also have a pending evading and felony court, Your Honor, and so one of the things that we're interfacing with felony is, if they were to put him on probation, can they do DWI style?
Yes,
condition?
that would be
That would be-
fantastic.
I think in a world of sunshine, where everything goes the way we would like, he would go up to felony, get a treatment plan up there, and then hopefully Fort Bend feels that he's been sufficiently treated here with a conviction for DWI, conviction for the MAJ, and then his treatment terms, if that's what they decide to do up there, here, that they don't feel like they need to pursue their case and that whole
Let's do
gets
that.
released. So in a world where everything goes,
So
I would like it to go.
let's do that. Let's see if we can work a global for everything, and because he's here anyways, I guess. Musica has felony.
Got him
court.
here today, and do you represent him in felony? or
I
is
do
that
not,
somebody else?
and he told me that he's talking to his attorney there about seeing if it can be reduced to a misdemeanor. I don't know if they're willing to do that for a misdemeanor deferred. Well, Judge, I just don't know.
So let's do this. You still have to get the okay from upstairs or what?
I'm just waiting to hear back from them, and then if we don't hear back, I'll just run up there and go talk to them.
So you don't have to do all that. I mean,
Fine.
really, if
I
you
don't know how
want
to use a computer, so I'm pretty useless. I'm running up and down the stairs is the thing I can do.
like a day or so just to figure it out, I'm okay with that. If you get the approval now, then we can do it as well.
We just don't want him to get a long reset.
I was hoping that we could do
And
I was hoping we could do a global so that everything takes care of,
Well, part of it is, I think, he's been motivated to not work out his felony because he's stuck in here anyway. So I think that.
I'm willing to work it out
Right.
because I know that Fort Bend really ties us up and I wanted to put him in treatment. Ever since day one, they said we had him TRAS to say, put him in treatment. And I was convinced not to. And then he ends up picking 3 other cases up.
we'll coordinate with felony to see what they're case and what they are planning to offer.
Yeah, okay.
And then,
Yeah, I'm down with whatever.
we can
Sure. So
coordinate with his defense attorney up there.
if we don't hear back today, just roll it to maybe a day or?
Day or 2 or whatever. Yeah.
All right. Sounds good.
Is he even here?
No, he's here, Judge. I've been talking to him back there. Okay. All right. Thank you, Judge.
Thanks, Your Honor.
Let's get into the heavy hitters of legal theory. When a defendant is already wanted in another state for a high-value financial crime, is it ever truly reasonable to allow bond based on a voluntary surrender promise? Or do these fugitive cases inherently carry such a massive flight risk that release becomes an impossible gamble? We're talking about people with the resources to disappear forever, and the court has to decide if a pinky promise to return is worth the risk of a high-profile escape.
Your Honor, Happy New Year. I haven't seen you. Your Honor, I'm here on Angel Rodriguez.
Okay.
The DWI PTI. We have this contract today. He has the portable. He just got the portable yesterday. He just paid the DA fee today. I'm going to have him sign everything. I'm asking that this case be rolled for tomorrow so then I
I'm
can
okay with that.
get to the office and have it
For sure.
scanned. And so,
Yep.
Thank you so much. Okay.
And I mean, if you have everything done, everything's signed, and they're ready to file the supervision order, I'll waive the appearance so you don't have to waste his time coming.
Thank you so much, sir.
Hey, of course.
Your Honor, I have a case on the docket tomorrow. I was wondering if we could look at it today.
Sure.
Case number is 251.
Okay, 5-4.
251
Oh,
8895.
it's old.
It's 190, I think, Judge, something like that. I've submitted the mitigation. I submitted the application. I think it's changed now. We have to do them together. I'm just waiting approval or denial. His court date's tomorrow. I was wondering if I could get 1 week.
You said he done the TRAS?
No, but if I get approval today, I'll bring him in tomorrow to do the TRAS. But if I get denial, I'd like to bring him in next Thursday for a plea or trial. Kind of deal.
Appeal.
For a plea or trial, because he's being offered time
Are
served.
you not going to try to appeal?
Appeal?
Yeah.
Oh, the mitigation denial, if it gets denied, I can appeal it. I mean, from what I understand,
Hey, tell me,
So,
BAC is, what is it?
so the last thing we have is from,
No. What's the BAC?
oh, DAC.
0.16, Judge.
Yeah.
Yeah.
No accident, no criminal history.
I don't, okay. I've had 3 denied today, but they were high BACs. So, yeah.
So
So-
optimistic.
Yeah.
If I get approval today, I'll schedule the TRAS as soon as possible.
You can bring him in, we can do a walkthrough.
Okay.
So whatever you want to do. I mean, the case is 203,
I
right?
thought it was at 190, but you might be right, Judge.
I'm looking at someone else. So if how long are we looking if they set TRASs? Is it,
Typically, regular TRAS, no circumstances to be submitted, maybe 1 or 2 days.
oh, for the appointment?
One more time?
To make an appointment, it's 1 to 2 days to get them in?
Make an appointment, I could do a walk today and see today.
No. But if he wants to call to make an appointment, is it like a week to get them in or 2 days?
Oh,
Or
no, they can get them in immediately. I
Okay.
can email them.
whatever you want, Ray.
Okay.
Yeah, we'll set you off for a week. If you get the approval before then, just let us know.
That's all I asked. Thank you so much, Judge. All right, thank you.
It's on tomorrow.
Do I email it to her?
You're right here. Just do it now.
There's nobody. Sebastian?
Judge, I'm approaching on Kenneth Asanga. He's out of state fugitive.
What's the last name?
Asanga. It's spelled Asanga. He may be in holding. He's in custody.
Oh, I see. Is it a fugitive case?
It is a fugitive case, Judge.
Got it. Hi, Amy. How are you? Okay, I see it.
Are you hired counsel?
Not just yet. The family's trying to gather the funds. I was just mentioning to the court that that's what they're trying to do for now. And I'm also reaching to get a little more information that would be helpful to this court and to their.
Well, here's the deal. I have to appoint him someone. So I'm going to appoint him a lawyer today. I cannot have him in jail without giving him a lawyer. So
He's appointed the lawyer already. I just.
it's Asanga. So Stacy Morgan is the lawyer that's been appointed so far.
Okay, Judge.
I really can't get into the nitty gritty of the case because he has a lawyer. So if you get hired on, let us know, and then we can, go forward with telling you more about it.
Does he know Day? Does he know Day? Do you know Day? Day Kim?
Day Kim? I do not.
Okay.
Okay. I guess just keep us in the loop because we're going to work what we normally do. I don't know what's going on with the case now, and I can't get into what has happened. So, but these things, typically move pretty fast, just to give you a heads up.
I understand, Your Honor.
Okay?
All right. Thank you so much. And I will take the court once I'm retained. Thank you so kindly.
Thank you so much.
All right. Have a good day, guys. Bye-bye.
Okay. Thanks. Are you ready?
Well, that wasn't confusing at all.
Anytime you get stuff where there's in county versus out of state, it just,
No, it's all.
there's just so many rules that just kind of
And Judge,
clears mud.
No, I know it. I've seen those issues and have dealt with just enough to know I don't enjoy them.
Is our guy on docket today?
No, well, he's on docket, but he's here present in court. He made bond, so that, I guess that gets rid of the issue about having to.
Coming up.
BVR.
Last name again is?
Gomez, and it's Matthew Gomez. You may have a couple on the docket. And did invite us to rehear PC this morning. The case I know is 183 days old. I have talked with the state. They're still trying to work with felony to see if they would approve him to do a mental health PTI, which we thought was appropriate.
Mental health in the case upstairs or our case?
Yes.
Are you ready for a PC? Blaze?
So, Your Honor, I think
Our understanding was just reading of it. I didn't know if you want the actual officer here or not.
No. This is just cursory, but I want to know if you're ready for any arguments or whatnot. Yeah. Okay.
Yeah, we're not addressing the new one whatsoever.
Yeah. No. That's
totally good.
Tell me. Go for it. Alex, please.
On August 25th, 2024, the officer was dispatched to a complaint unknown call at Harris County, Texas, with a call slip stating the following. The caller was rambling and refused to answer questions. The caller advised he has warrants for arrest and wants police to pick him up before he does something. The caller states he will be waiting outside the location for police. The caller was irate and upset. The caller was making threats towards police, stating they better be strong because he was going to fight and don't dispatch female officers. The officer arrived on scene and immediately noticed the defendant coming out of his house in an aggressive manner. The defendant took off his shirt and hat and was coming towards the officer quickly and was trying to get the officer to physically fight him. The defendant repeatedly stated he wanted the officer to fight him, and the officers immediately drew their tasers and began giving the defendant verbal commands. The defendant repeatedly refused to comply with the verbal commands and continued telling the officer and his partner to put their tasers away so they could fight him. The officer took the defendant to the ground by tackling him and used force to put the defendant's hands behind his back. The defendant was physically resisting and yelling the entire time. The officer then got the defendant into handcuffs and moved him to the side of the patrol vehicle. The officer's partner held the defendant against the vehicle while the officer conducted a search. The defendant was still refusing to comply with verbal commands and was physically resisting. The officer then assisted the defendant into the patrol vehicle using the minimal amount of force necessary, and the defendant was kicking the officer's legs and still refusing to comply.
Did they find anything? You said they searched, but they didn't find anything?
There's no notes, no finding anything completing the search, and they only know that they arrested him on the warrants as well as the additional resistance charge.
What warrant did he have?
He had municipal.
I'll give you a second.
Municipal warrants, Your Honor.
Just municipal?
Yes.
Okay, all right.
Yes. But I think a couple things are, and I know that's the DA's summary of the longer dims. And the longer dims notes reflect that when the officers got to the scene where they had been asked to come out and make an arrest and or been asked to come out and told there's warrants, but they get there and they don't have a chance to confirm anything or find out who he is or any of that stuff. But what's written in their longer dims report, the officers write down, he asked us to put our tasers away and fight him. And so it says in there that the officers made the decision to put their tasers away and go hands-on with him. And so that is.
You're saying, you're telling me that they agreed to fight him?
It's what they wrote.
Can you imagine how much possible trouble they would get if they would agree to something like that?
And I don't think that it's agree to fight him in the sense that I'm not saying the officers did anything wrong whatsoever. I'm saying when you arrive on the scene and somebody says, I have warrants, we know that's not enough as a legal matter to make an arrest. I could walk up and say, I've got warrants to our deputy. I can't be arrested for that. Maybe he can go back and find out more information, but that's not enough.
I think that's reasonable.
Yes.
Yeah.
But then the conduct is not that he comes up and starts fighting with the officers, but invites them to engage in physical contact. And I give them credit for putting their tasers away like he requested, but they write in there, we did exactly what he said. We put our tasers away and then decided to go hands-on with the suspect. It's 2-on-1.
But I don't think the reasonable interpretation would be that they are agreeing to fight.
Well,
I don't think that that's reasonable because I can't imagine how much trouble they would get in. They'd be fired.
To me, it's not about whether no one over here, and I don't think the state is either, is saying that the officers did anything wrong. I think we're assessing his conduct, and he has the right, as does anybody, it's just First Amendment protected speech, to invite someone to engage in physical conduct. And if they do, that's not him resisting arrest. And I don't really even think that that's the kind of the basis of the charge. They can't even arrest him because there's nothing to arrest him for at that moment. If you ran his name and found out the warrants and found out he did have active warrants, you could arrest him. But there's nothing for them to even arrest him for at that moment. And just walking up and saying, hey, I want to fight you, that's not enough to be placed under arrest. But what happens is they get him and get control of him and then start searching him. But pursuant to what? I mean, there's nothing. They still haven't verified him.
No, I think that it's so difficult to be a police officer nowadays, you know?
I understand.
A fine line that you have to walk between because of social media,
Sure.
because of cameras, because of just the way that the public policy and people come down on officers and how they react to situations and how they can get in trouble themselves. That if you see a person who's not acting normal, they're having like a mental health episode. How do you quell that down? Do you tase them? Because we know that we've got situations where officers go rogue and they just start kill them.
No, well, we've seen it too many times. And
it's really, and it sucks. It's sad, but.
And I'm not criticizing the officers one bit about that. If it's the case that he tells them, when you get here, I want to fight. And when they get there, he says, I want to fight. And put your tasers up and fight me. And they put their tasers up and decide to go hands-on with him. I respect them for having done it.
I would like to know, because I'm not prepared to rule on this. What I would like to know is, what is the policy of the department when you have a person who's having a mental health episode? How do you handle that? Do you arrest them as like a community caretaking, right? Because in an effort to prevent them from hurting themselves or hurting another person, do you arrest them, right? Or what do you do? Because I don't know. So, because that's what's happening here. We have someone clearly who's having a mental health episode.
Well, and you see why I thought mental health PTI is the appropriate route.
Yes, absolutely. Yes.
So, and I don't mind being patient while you think about that, and I go back and.
I'd like to know what the officer's mindset, number one, at the time of when this episode is happening. Number two, what is the policy when you have this kind of thing happening? What do you do? I don't know. You know?
Sure.
Do you arrest them in an effort to prevent them from hurting themselves? Because who's to say they might have a gun that you don't know about that's stuck right here that they're going to gun, they're just going to start shooting?
Well, but I do think that it doesn't mean that he has done something legally wrong to elicit the words, this is what I'd like to do, and wait. It'd be one thing if he comes and starts attacking them, but to say, put your tasers up and fight me, and they say, taser up. We go hands on. Hands on for what?
I think that was extremely brave of the officers. I give them so much credit because, I mean, who's to say that he doesn't have a gun behind his back and they just don't know, and they're trusting him that he's going to act honorably and not take a gun from behind and kill him.
That's what they said, Your Honor. They actually used less force than would have been.
Really? God, that was freaking awesome.
Again, this is not criticism whatsoever.
Yeah, I understand.
But
I understand.
The question is, what legally did he do wrong in that moment? One, to support a detention. Two, to allow for an arrest. And I don't know that there's enough for that. Or either one of those. It may be enough to, I mean, I don't know if I walked up to our bailiff and said, I have warrants, if that's enough for him to even detain me. I mean, there's just no corroboration whatsoever.
So if you have someone that's coming up to you and threatening to assault you, right? Is that a crime?
Well, yes, but that's not the same.
There you go.
Well, no, that's not the same thing, Judge, because I can walk up to somebody and say, hey, would you like to fight? And that's different. That's not threatening to
You
assault.
have to take the circumstances into account. There's a totality here. You can't just take the statement in and of itself. The person's having a mental health episode. They're irate, right? You don't know what they're capable. You've never met them before. If I know you and you ask me to fight, that's a different question.
Well, but I don't know.
Versus I've never met him.
Turns on.
He's got warrants. He may have a freaking murder warrant out.
Sure. Well, but they
know about it because it's on the call slip.
Well, they know that he said that. They hadn't verified it.
I understand, but it's still there and it's still in their mind. Damn, this guy's, there's a crisis here. How do we avert this crisis from happening?
And I respect that portion of it for sure. But from analyzing whether or not there's probable cause to support the elements of this charge, I think that's where our focus really is at.
There's so many like branches to this thing. I can't possibly rule right now.
No, fair enough. And I appreciate that. just from the state's perspective, I know that we want to get a little more information on it. I respect that. I think you have, just looking at the totality of the circumstances here, you have a call slip that says someone is, I think what the exact thing was,
Yes, warrants.
rambling and refusing to answer questions. He's advising he has warrants for his arrest and wants someone to pick him up before he does something. States he's waiting outside. He was irate, making threats towards people. They, at the bare minimum, have someone that could be a danger to themselves or others. They go out, and I know this is somewhat weird to say, but he approaches them in an aggressive manner with his shirt off, saying, "Come on and fight me." I would argue at the bare minimum, they have the right to detain him. A, to confirm those warrants, because they can't confirm those warrants without actually speaking to him, getting his ID, that kind of thing. B, then there's saying, "Come on and fight me," to a uniformed police officer. I know you're not ready.
There's just too much. There's too much.
Well,
you're incapable of verifying the warrants because of the episode that's happening. So,
but the actual charge in terms of the elements of this case are that he resisted a search being effected at the end of the fight. And all I saw there with respect to that portion of it was totally conclusory. And so that's where we think the PC falls apart on the element side of just this particular charging issue. And, but I want to again make it abundantly clear that we're not criticizing the officer whatsoever.
I know you. I get. No one is.
It is a complicated situation.
Taking it in any,
But we did think, and that's why the case has gotten to be 180 days old. I think we're at 182 right now, is because I've been trying to find out more and trying to work to get him approved for the mental health PTI, because that kind of
is now what happened upstairs going to throw a wrench in it.
Yes, it has currently. They're going to reapproach felony and see if they'll still allow us to go down that route. But I think it's really the most appropriate route. And I'm not going to go into that case upstairs, but the allegation in that case, and I think legislature's made that a second-degree felony, if I'm not mistaken, assault of a peace officer. But the allegation is that his thumb.
Second degree.
Wow, the legislature made it a second degree now?
Yes, Judge.
Yep. And
holy moly.
And I understand.
Wow.
But the allegation upstairs is, and I know there's different components to that whole fact pattern, but the allegation made the basis of the assault is that when they were trying to reposition his handcuffs, his elbow hit the officer's thumb. So it's not.
Oh, I thought here when they were reading it, they were saying like he was kicking and screaming and kind of
On
like.
the older case, Your Honor, he was. On the newer assault case is whenever they tried to put restraints on him, he pulled away and struck the officer's thumb with his elbow. That's for the felony, Your Honor.
It'll be interesting to see if there's body cam to see what the nature of that pull was, right? Because that's ultimately, the case lives and dies on probably that,
But
right?
from my perspective, and I hope that felony is in agreement with this when they learn kind of more about it, and it's a brand new case for them. But when they learn more about it, I hope that everyone agrees that if there's mental health issues, then we solve that problem. So this young man isn't back here. And if he gets resources.
We're very lucky, my friend. Very lucky. People have died for a lot less. You got to be very careful in today's society. You never know who has a gun. I have a friend of mine that had a person that was road raging behind him. Just because he wasn't driving fast enough, the guy comes out, gets a knife and stabs him. Did nothing just because he was driving slow. You never know who you're going to run into these days, man. You run into the wrong person for a lot less, they'll shoot you ass dead. Got to be careful, man.
And the advice that I've heard you say it in different ways is don't make permanent decisions based on temporary emotions. And
life's just too short, man. You get one crack at it. Once it's gone, it's gone. Just all right. I'll do whatever you want to do. I'm not ready to rule in it yet.
But I do think also I was asked to get bond conditions put in place while he's on a new bond. And what I'd like is the same old bond conditions. What
do we have now?
A new offense. Don't consume alcohol or
just be good. 99% people lose self-control. That's why they're in jail.
Yes, sir.
No self-control. You got to think. If I do this, what's going to happen? If I say this, what's going to happen? You got maybe a nanosecond to think about it. But that's what it's about. That's what makes you mature. Look at all those freaking old guys in there. Never grew up. Never grew up. And they'll never grow up. Yeah, I'll stick with the same bond conditions. Just no alcohol, no dope. Don't use, man. You know, is he taking any medication now?
No.
Okay, just be careful, man. Self-control. Got it?
Sir.
Just stay in touch. All will be good.
Yes, man. Great contacting me, you.
Okay, I believe it. Okay, Mr. Gomez, good luck.
Thank you as always.
We are diving into a much deeper, more provocative legal question today. If a citizen actually calls law enforcement on themselves during a clear mental health crisis, yet verbally challenges the responding officers, does that friction alone establish probable cause for criminal arrest? It's a terrifying gray area. Should a desperate plea for help be met with handcuffs in a cell, or should mental health intervention take absolute priority over criminal prosecution in these volatile situations? The line between a criminal act and a cry for help has never been thinner.
Mr. Enrique Rodriguez, I received an email from pretrial services stating that my client, Mr. Enrique Rodriguez, failed to go and to pretrial service and pick up the portable device.
Is Mr. Rodriguez here now?
Yes, sir. He's here, Judge. Mr. Rodriguez, come forward, please. I think he was supposed to get it by 1:13. Yes. 20.
You don't have the devices we ordered you to do?
No, sir. I have a letter from the State Department of Transportation in Austin saying I am
no.
to drive a car, so I figured I didn't have to get it. So I can't drive. I didn't know. I figured since I can't drive, why should I get it? And then
Because I ordered you to get it. And now I'm revoking your bond and I'm putting you in jail because you've been a whole month without having it. You decide on your own? Of course, don't work like that. It goes with you.
Thank you, Judge.
Well, Mr. Kim's on Zoom. I'm approaching, I spoke with my client. My client would like me to approach to ask for a bond so he could go and turn himself into the demanding jurisdiction, Worcester County, Maryland. And so.
What's the last name?
His last name is Mr. Baptiste, B-A-P.
Good morning, Mr. Baptiste.
Good morning. How you doing?
So I don't know. You know, I don't know anything about you. I don't know what you're wanted for. I don't know what kind of criminal history you have. You know, a lot of times, whether we give a bond to someone depends on what they're charged with, what kind of criminal history they have. I know that you're going to tell me it's little bunnies jumping in the woods, but everybody tells me this guy's purple, blue, black. So, but paper really tells me who you are because that's how we get to know you in the short time that we have.
No problem.
Mr. Kim, would you like to tell me about him?
Your Honor, he's wanted out of Yavapai County, Arizona for 6 charges, including fraudulent schemes and artifices.
Wrong case.
Wrong case.
Oh, sorry, wrong case. He's wanted out of Pasco, Florida for battered prior.
Wrong case.
0 for 2, man.
Where are the ones?
Baptiste.
Maryland.
Hold on 1 second, please. Oh, here we go. Sorry. I was reading a different warrant. Okay. He's wanted at Worcester County, Maryland for theft, but he's wanted out of 6 charges. 1, 2, 3, 4, 5, 6 charges, including fraudulently intending another's identity to use that information to obtain a value of item and currency totaling a little north of $80,000. He's currently on a deferred adjudication for an aggravated assault. And prior to entering in the deferred adjudication, but after he was charged, he was also charged with carrying a handgun in a motor vehicle. State would be opposed to a bond, Judge.
So, okay, you went kind of fast on. So he has 6 open charges in Maryland or just 2?
Yes. So he has 1 count of $21,455.50. He has another count of $10,700. He has another count of $10,695.50. Another count of $42,851. One count of fraudulently intending a possession of personally identifying information, and another of fraudulently intending to obtain another item of or identity, assuming an identity of another individual to obtain an item of value.
Are all these? Is it like a theft from a person?
It was a fictitious wire transfer for at least one of them. I'm looking at the affidavits. One is routed through PNC
Do we have
Bank.
actual complaining witnesses or victims, especially on the one that's like a 40,000 gig?
That one I can Hold on. Here's an account, withdrawal. I mean, I can't tell if it's from the bank or from another. If I could just have 30 seconds, I'll take a look at the.
And how old are these cases? Are they new or are they old?
These are relatively new, Judge. This one is from June of 2023. So obviously it was after he entered into deferred adjudication for the aggravated assault. Obviously violating his conditions of the aggravated assault. But
let me tell you the problem that I have, Mr. Baptiste.
Okay.
And the way you conduct yourselves in court and the way that you conduct yourself while you're on probation tells me a lot of who you are and whether you will submit and comply with court orders. Because one of the things that we have is when I give you a bond, you have to go turn yourself in to the demanding jurisdiction within 2 weeks.
That's no problem.
Great. Well, the first thing I did was I wanted to look through your history with the probation that you're on. And in the first thing that I pulled up in this bond violation report, I have here, 5th violation report submitted for failing to report to the bond unit as scheduled. This is the alleged probation that you're on.
That was waived.
Stop. I don't want you to explain anything.
I know.
The only thing I'm trying to impart to you is the way that you've been on your probation and the fact that you've picked up the 6 cases in Maryland in 23 or 24, whatever it is, and the amount that it is, tells me that it scares me to give you a bond because I don't think that you will comply. And it's unfortunate because I don't like to keep people in, but the reality is paper tells me who you are. And all those bond violation reports, the 6 new cases.
Sorry. Things, if I may, the 6 cases, it doesn't make a distinction whether there's 6 separate transactions or it's all one happening at one time. And so he hasn't been able to answer for that. This is only from 2023. He would like an opportunity to do so. He is going to work out his felony case when he gets up there tomorrow. He's going to have a chance to work it out. I don't know if he'll be able to work it out or not, but it's his first opportunity to do so tomorrow. If he makes bond up there, would you consider giving a bond then? No.
It's just the way that the probation has played out. Okay. And the fact that he has 6 here, I think in my heart of hearts, if I set you a bond, that it's just, you're not going to show up. You're going to do what you want to do because that's what history tells us.
Okay.
Sorry.
I understand. Thank you.
Okay.
Question. Would you mind explaining to me?
This is not, no. This isn't where you get to do what you want to do.
Let's go. All right. Thank you.
Ask your lawyer. And then if it's something, you can talk.
Thank you, Judge.
Thanks. So tell me what we're doing with this.
Judge, this is a fugitive case. Mr. Day, I believe, is on Zoom. I am requesting to see if you would consider giving him a bond so he can go turn himself into it's Yerpe County, Arizona.
Yerpe, el condado de Yerpe en Arizona.
The lawyer is asking for me to set you a bond, Mr. Pasos Miranda. I don't know. I have to look at several things to see whether you would be a good candidate. Number 1, whether you would actually go back. Number 2, are you a danger to our public? So Mr. Kim, tell me about Mr. Pasos, please.
Yes, Judge. This is the one from Yavapai County, Arizona. And he's wanted for charges of fraudulent schemes and artifices.
Wait, fraudulent what?
Schemes and artifices. This is just how it's written.
Schemes and artifices?
Fraudulent conspiracy to commit fraudulent schemes and artifices.
Okay.
Fraude.
1 count of computer tampering. 1 count of theft.
Una cuenta de alterar computadoras.
And one count of
hurto,
criminal damage.
uno de daños
So
criminales.
4 total counts.
But it's out of the same transaction, Judge,
Casos.
on
Sí,
March 20,
por la misma
2023.
transacción que ocurrió en marzo 20 de 2023.
State would be opposed to a bond.
El Estado no quiere dar, no está de acuerdo con una fianza.
For these charges, it looks like he messed with fuel pumps at a mini mart.
Estaba haciendo algo con las bombas de petroleras ahí en un minimart,
To include computer tampering.
incluyendo que estabas alterando algo con computadoras.
But 1 year after he committed these offenses, he also was charged here
Este delito también lo acusaron aquí.
for a similar offense of violating motor fuel tax requirements.
Por violar los requerimientos de impuestos de petróleo y vehículos.
And here before that,
Y antes de
for
eso,
a misdemeanor charge of theft, but again,
un delito
regarding
menor
fuel.
de hurto, pero igualmente era de
He
petróleo.
also has a prior fugitive case, I see.
Tiene un caso antes de
I
fuga.
didn't see that when I pulled it up.
From 10/31/24, I see a prior fugitive case out of the same jurisdiction.
La misma jurisdicción.
Yavapai County.
Yavapai County.
So he's been before you, is what you're
No,
saying?
it would happen if he was
No,
a
dice
fugitive and he
que
was
era
apprehended by
fugitivo
another
y
state.
agarró otro estado.
It could have been by this warrant or another warrant.
Puede haber sido esta orden de arresto o otro.
Oh,
Una
but,
otra
but because it's resolved, that's why it's closed on our end. And I
but let me
can't
ask you
find
this.
it.
Did he know about this in 2024? Because if he did, I'm not giving him a bond.
He's saying he didn't know, Judge.
I see state jail. So I see a fugitive case and I see a state jail sentence of 7 months, both on the same time out of work. So it looks like there possibly could have been something that he pled to in Wharton County. He got also hit with fugitive case. Because he got 7 month sentence, they probably, you know, didn't the fugitive case.
This is a lot of, we don't really know what happened.
So let's do this. Let's roll it to tomorrow.
I've had him in felony,
Dice
and I
que
know that he
yo,
pled
en
to
el caso
the
de
7 month
felonía,
state jail.
sé que
And then
te
he was brought over
declaraste
to Harris County.
culpable,
I don't know if that helps,
culpable,
but
7 meses
I
en la
Represent him on the fuel tax in the 185th?
Yes.
Oh my
He
goodness.
did.
What are the
That's
odds?
just opportune.
Huh?
That's why I'm like, if,
Just go play the lottery.
so, if that help, I don't know if that helps, but he was
So-
brought over.
Ella fue
from-
tu abogado, dice.
Sí,
Está hablando.
Did he do 7 months state jail? Because I show a sentence
No,
of
that's
7
still
months.
pending. So they're
No,
going to
dice que
send
se
him,
está pendiente.
Still pending.
todavía.
right.
7 meses de
Yes.
cárcel.
I know.
No,
Sorry.
there is a, ya terminaste, because when I had him, there was a hold. Ya terminaste con el caso in Wharton County?
Yes.
Okay, because when I had him, he still had a hold. If there is no more hold, that
They
means.
run an
they're sending-
NCIC?
Yes.
No.
I don't show another hold right now. I mean, there might be a warrant, but it's not attached to a spin that I can see.
It was
Ellos
there
no
when
ven
I had
ninguna
him,
What did he
Judge.
have in Wharton County?
Que tenía
If anything.
other words, que tenía algo.
It would have been a credit card or debit abuse. He was
Pero que
convicted
abuso de tarjeta de crédito por
on
It's
October
the same
15,
thing over and
2024.
over and over, you know? It's over and over.
Y dice que no lo puede hacer porque es la
They-
misma cosa de
it's-
vuelta y de
It
vuelta.
appears to me that Mr. Pasos Miranda continues to pick up the case
Sigue
over
agarrando
over
los
and
mismos
over.
casos.
These fuel tax
Igual,
violations
igual,
where they
igual,
they allegedly get,
violación de-
you know what I mean?
Sí, pero
So we've got one in Wharton, we've got one here, now we've got one in Yavapai County.
se llama Pan County.
So is it because of the types of cases he's picking up, or
Not
are we
this
going
one,
back?
but
tipo de
it's- It keeps happening.
Okay.
Right?
Sí,
It's
no es por el tipo de caso de que sigue
it's over and
ocurriendo.
over and over for the last three plus years.
What I was gonna
Mismo
do,
por
I thought we
años,
were
sí.
going in a manner where I needed to figure out if he was aware of the warrant or not. But if that's not the case and it doesn't make a difference,
Judge, may I jump in again?
Of course.
It looks like they lifted the hold
Parece que
on 218.
te quitaron.
If I'm looking on the DA portal,
Dos.
they placed a
18.
hold on him
Porque te
on
pusieron una
October
orden de
31st,
detención el
2024 for that
31 de
sentence for
octubre
7
para
months
la
state jail.
sentencia de
And then
7
they lifted
meses.
that hold
Después lo
on 218.
levantaron en
So he's done with that
18.
as of
Él ya
218.
terminó con el 18.
Yes,
de
I can
febrero.
show it to you. Well, I don't know if I can.
How?
show- Because he came in on a warrant, so his time would have
Él
ran
vino
concurrent
en una
while he was in
orden
Harris
de
County
arresto.
and we were
Entonces,
working
So
out.
you know what it is? It must have been, you know how on out of county cases, they give you the 10-day, right? And if they don't come pick you up, they release the whole within 10 days. That's what. it's
No,
probably-
well, so sorry, Judge. For this one, for the one on February 18th, that's for our 185th violation of motor fuel tax. That one, the release hold was on February 18, 2025. And then that triggered the in-county extradition for likely Wharton County for the out-of-county. That one was released on February 21st, 2025.
La orden esa te la quitaron.
But effectively, both of them, because they're state jail, it would have run concurrent. And at this point, based on when he was taken in, it's likely time served.
Which would be taking care of the Wharton County, and Wharton County is no longer in play because of the time he spent.
We don't know
in here.
that for sure, though.
Well, we know that, well, yeah.
No, right? So let's do this. Can we roll it to tomorrow and you can try to figure out?
Yeah, let
So
me
we have
figure
a
out.
concrete, you know?
Let me get everything in place. I'll roll it, try to get some confirmation on Wharton and figure out if he had knowledge of this case out there.
I mean, I have a concern if he knows that this is open, because it's been open since 23.
Right.
Él sabe, de hecho está abierto desde
I get it.
2023
I'm gonna continue to like let him slide when he knows it's open.
Let me get all this in place and we'll reapproach. Okay, let's do that.
This leads us to a pivotal question that could change the course of the entire trial. If a defendant stands before the bench and claims they genuinely misunderstood a court order, believing that compliance wasn't actually required, should that confusion excuse the violation? Or must the court's mandate be followed with absolute life or death precision, regardless of how an individual chooses to interpret the law? In Fleer's courtroom, a misunderstanding could either be a valid defense or a one-way ticket to a contempt charge.
Coach, and I've been back a couple of times trying to amend the condition for the mom. This is an alleged assault family violence between a mother and a son. Ms. Valvo is here. The state has agreed, and I think they've contacted someone to change her bond condition to, we were just going to ask to allow for the texting and the phone call. And then you would ask them to do some follow-up rips.
So the defendant is mom.
Yes.
Complaining witness's daughter.
This is the, I believe,
Daughter's
15.
21 or 20?
Son.
The son is, he's 18, I believe he's a senior in high school. He's living with a family friend right now. And we are okay with amending bond conditions to allow communications over cell phones, so they can still text and call. But we would ask the court to hold any in-person contact.
And Judge, we would ask to allow her to go to his sporting events. No contact with him there, but she'd like to go watch him at track.
No, I mean, it's
And
invariably
football.
going to happen where she's going to get overcome with emotion. Then she's there. He's 2 feet from her.
Then she'd
Know
be
what I
on the
mean?
field and she'd be
It's
on the
like-
stand.
It's like holding a candy in front of a baby. I'm sorry, not a baby, but like a 13-year-old kid.
Judge,
You
I
know?
believe she could stay in the stands. and
Malvo,
he'd be
come
on-
up.
And he'd be on the field, but
I don't know. I mean, I don't think that's
Jose Montes?
it's setting up for failure. I think. The only thing I want in the short life while I'm here is to protect every single complaining witness in these cases, in this county, in this state, as much as I can. And the problem is that temptation is so very high. We have at this moment a no contact order. You're not supposed to have any contact with this person. Your lawyer's asking for me now to allow you to have contact and texting privileges so that you guys can have some kind of communication. The state is still opposed to having you in-person contact. And the problem is that if you go to, and I'm inclined to, agree about in-person contact. The problem is that if we allow you to go to these sporting events and he's 2 feet away from you, the temptation is so high, it's invariably going to happen. And we're not there to see whether it happens or not. And so therein lies the problem, is that I will never be able to monitor the fact whether you actually have contact with this person or not. And that's a problem, because the last thing I want is you to pick up more cases or this person to get more hurt.
Talking about in person. Y'all have him as 18?
We actually have him in the up there, river page 16.
Yes, Judge, he's 16. He's not 18.
The birth date was listed wrong.
It's okay.
And his father's in jail.
Remind me about the assault, please.
Sorry, Your Honor?
Refresh me about the assault, please. How bad? We're talking.
Yes, Your Honor. So the assault took place in June 2024, and the victim was identified, and the victim explained how his mother, the defendant, assaulted him by biting.
Biting?
Yes, Judge. You see. So the victim stated his mother was angry that he was in the way, and as he was holding her two wrists, she raised her hand up to her mouth and raised his hand up to her mouth and bit his hand. The victim stated he felt pain, was in fear, and the victim had a visible bite mark on his hand.
Judge, the son is holding her first, just so we're clear on what's happening.
I mean.
Yeah,
Yes,
but
it does
he's
state
not
that.
quite saying that.
Well, it does
I
state
mean,
fully
what
that.
circumstances happen to where a 15-year-old grabs mom, right? I mean, perhaps they were fighting, I don't know, but the fact
Judge,
remains is that
there's been no facts and nothing in the probable cause that I've been given or that I've shown that any of this was between the mother and the son. I believe it was between my client and another lady, and the son comes and holds her. I believe that's what the
So-
facts will bear out.
he's trying to protect her. He's trying to, I guess, de-escalate the situation.
Judge, I believe that those would be facts that I would want to
Right,
try.
I mean,
yeah.
I don't know. And so, right, same thing. I mean, regardless, what we
facts
do
that
know,
I'd want to bear out, but it's not like she just walked. I didn't want when you're making your decision for you to be basing it on what it sounds like she walked up to him and bit him. That's not how it happened.
I get it. Thank
Thank
you.
you. Thank
Because,
you.
and I mean, the idea is that we really want to know under what circumstances everything happens. That's why with every case that we have here, we really delve into it as deep as we can to determine, is there a probable cause? What circumstance should we have as far as contact or no contact? Guys, what do you think?
Judge, we're okay with them texting and calling each other to catch up.
What does he want? I mean, at the end of the day,
So
we need to find out what he
It's a little bit of
wants.
a complicated situation in terms of the complainant's guardian, because he is 15 and said he's living with a family friend. What we do know is that he does not want to be living with the complainant, with the defendant. He wants eventually, I think his essential goal is to get emancipated. We do know that. We talked to the person that she's living with and says that they have been texting already. So because of that, we're okay, and that they're
Are
okay
you
with
texting
it.
already in violation of a no contact order? If that's the case, I mean, I've got it. We'll take issue with that.
So, this was based on the talking to this parent. She wasn't entirely sure.
Do we have a no contact order now?
I'm not. Not entirely sure. And the other thing is that we haven't confirmed that with the complainant itself, a 15-year-old. So at this point, we don't have evidence to move on a
Right.
violation of a protective order or anything at that point. But it seems like the kid is okay with calling and texting, but hasn't.
But you don't know
indicated to us
that
they
for sure, though. You don't know that for sure, right?
And Judge, as of December 18, 2024, there was a no contact order in place.
I hope that you're not having contact with this person.
not having that.
I hope. Just, let's do this. Why don't we set this off for a couple days? If you could please reach out. I want to know what he wants or she wants.
Judge. Taking her in school is really hard.
I want to honor the complaining witness's wishes. This is that they just don't know.
Well, Judge, can I just recount this? We've been asking them to know this. This is the very first time I was appointed, I approached you on this. You asked them the exact same questions. They've done nothing. They can't get in touch with the complaining witness. I came back on February 2nd. I came back on February 3rd. I came back on February 10th. I came back on February 11th. I came back on February
I
12th.
mean, I agree with her. That's kind of, that's,
And that's why the book are agreeing to have that full section, which is what.
but you still don't know.
We have talked to the guardian, we just haven't been able to talk to the kid. The legal guardian is an aunt who does not live with the complainant. Who we're talking to was a family friend, we've talked to her, we've given her multiple calls.
So,
We just haven't been able to get.
so let's do this.
Judge,
Let's,
that's a misstatement. The sister's not the legal guardian. The son is living with a family friend right now. His father's in jail.
the complaining witness is a boy or is it a girl?
He's living with a
It's the boy.
schoolmate, Judge.
A friend from school.
He's living with a friend from
His
school.
dad dropped him
And she's
there
gonna do a
and went to
BIP. The
jail.
chief has offered a BIP and dismiss.
I get it. I understand.
A BIP and a parenting class. Sorry, he did tell me that, Judge.
I understand, but I always want to honor the complaining witness's wishes, right? So let's do this. I do find it unreasonable that they've been here as many times as they have, and you guys have been unable to do this. So what I would suggest is do this. Reach out to them and say that we're going to subpoena them to come to court if they do not get in contact with you guys. Because I agree with you that it's unreasonable to have to come back 4 or 5 times just to see. So let's set this off maybe like 3 days, 4 days. Reach out to them and say, hey, we are going to subpoena you to come to court. If you guys, you know, all we want to know is what's going on and whether you guys want to have contact and in-person contact as well. So ask everything so that you guys don't have to come back. Anticipate every single question that they're going to want known so that you can. Yes, Judge. So what we can do, you don't have to waste your time coming to court. We can set it off 3 days, 4 days, and I'll waive your next appearance so you don't have to come here. And then she can reach out to you, you know, phone that, because I don't want you to have to miss work or whatnot or anything. But I have to know what they want. And I don't want to work on speculation because
Is it what my son wants or is it?
it's what the son wants. I don't care what the guardian, I don't care who the guardian is. It's what the son wants. Right. I don't care about a guardian. It's not their decision. And I think that at now, what, 16?
16 years old.
He's old enough to know, right? He's almost an adult, so he's old enough to make decisions on his own at this point.
And Judge, we fully, and I've already accepted the PTI. We will get started on that. So even by this next setting where she doesn't have to appear, excuse me, Judge, she'll already be underway on the PTI.
Okay. I mean, the parenting class is probably pretty short, so it's,
It's
you know.
BIP and parenting classes, Judge. I'm sorry.
What is it?
It's BIP and a
Oh,
parenting class.
BIP and a parenting class. Okay.
I'm not really sure. I've got to figure out how long they want her in BIP and talk to her about that.
Got it.
So
Okay.
you can go sit down just for a second, then we'll get your case reset, okay?
Okay.
All right, we'll keep trying. Judge, I have one other one on docket today, and it's just a reset, and I've just been appointed today. Do I have to approach you on those? You've already found probable cause. It's Mr. Hall falsifying the drug
No,
test allegation.
no,
All right, then
no.
I'll just.
Just let him know that he's going to get drug tested about 50 days, just so he knows, and that's it.
What we witness today is the ultimate high wire act, a constant, grueling balance between protecting the community and preserving the constitutional rights of the individual. We watched a moment where mental health collided head-on with criminal law, leaving some defendants with structured opportunities for redemption, while others were stripped of their freedom based on a dark history of risk. Justice in this building isn't just about cold, hard punishment. It's about the razor-thin margin of discretion and the heavy burden of judgment under immense pressure. As the gavel falls, the haunting question remains: was the balance of power struck fairly, or did the scales tip too far?